When Article 50 gets triggered, then we'll have 2 years in which to renegotiate our relationship with the EU. So much will really depend on what that relationship is in the future, and there are various options. I mean, we could leave the EU altogether and sever all ties. That's probably unlikely. We could be a member of the European Economic Area, like Norway, or the European Free Trade Association, EFTA. But in both of those latter cases, we'd probably still have to be covered by a lot of EU legislation, just because it's unlikely that we'd be able to negotiate access to the single market without being bound by some areas of European legislation. So that's the first thing. And it also really depends on which government is in power when this takes force. So 2 years down the line of triggering Article 50, a Labour government might not actually want to do anything to employment legislation, whereas a Conservative government or a coalition government might have a different view. In terms of which areas will be affected, I think it's probably unlikely that whichever government is in power will want to reform employment legislation completely. We've got a piece of primary legislation, which is the European Communities Act 1972, on which a lot of the regulations that implement EU directives are based. So theoretically, if that piece of legislation were repealed, then these secondary pieces of legislation would fall because there'd be nothing to base them on. However, I think that's probably unlikely that that will happen, largely because that would create such a lot of uncertainty and confusion for employers that it really wouldn't really be worth doing that. So I think it's more likely that the government would probably take a piecemeal approach and look at individual pieces of legislation. And I can think of 2 areas specifically where there might be some scope for review, just because these 2 areas have been controversial. So the first one is the working time legislation that we have, the working time regulations, which are based on the European Working Time Directive. They've always been controversial for employers in terms of the limits they put on working hours and holidays as well. So that is something that the government might want to look at. The other area is temporary agency work. We have regulations that govern the rights of temporary agency workers, again based on the European Union Directive. And the regulations here, they're relatively new, and they are quite controversial among employers. So it's possible that the government might want to actually look at repealing some parts of that. In other areas, there probably won't be any change at all. And I'm thinking of areas such as health and safety, where UK legislation is pretty much ahead of a lot of EU legislation in that area. Discrimination legislation, and also equality legislation in the UK. So I doubt whether those areas will be touched at all. If we leave the EU, or if we're not a full member of the EU will want to ensure that there's a level playing field between the UK and EU member states in terms of employment rights, because it wouldn't want a situation where the UK would be able to undercut the rest of the EU. So it's likely that we're going to come under quite a bit of pressure to ensure that a lot of our employment legislation still complies with EU minimum standards. And this will avoid a situation where you have so-called social dumping, where labour is cheaper in the UK than in the rest of the EU.